For the reason how we started this webinar, from where it started, I also already mentioned. Once in Georgia, the special state of emergency and the law has been enacted to restrict the freedom of movements and other freedoms because of the real reasoning that the pandemic has been spreaded and there was outbreak of this virus. Of course, the question has been raised how we have to go, how we have to proceed with the proceedings as long the administration and efficiency in the conduct of arbitration, and of course, mostly how we have to go and with the hearings. First of all, we have to say that in this region, the Georgian government has imposed the first restriction. Then it was the very heart of the pandemic outbreak that all the economic activities and these terms, arbitration also has to stop its work. But hearings has been allowed by government, and we had the possibility to continue our work. Once, like other big and well-known institutions, and we have GIAC, I mean Georgian International Arbitration Center, we have many to adapt with this situation. We prepared, elaborated the protocols, notes, the technical instructions. We have assisted the tribunals how to work with the cases, and especially the virtual and the distance hearing. Everybody will agree that the distance hearing and it is not a new one, of course. It has happened, and new technology give us the possibility to make engagement of the parties, counsels from different parts of the world. It is not the new one, but still now many questions appears as long now we have it under the regulation. The law is on the table. So under the law, there is some restrictions which is binding upon the parties. So there are questions during the virtual hearing. At this point, I think that especially I have to recall what my colleague Ndanga was saying, that of course these at some point these webinars can be boring, but still it is very important because in our regions, as our center is covering the region and the many businesses and the parties have their seats from neighborhood countries, they are really affected with that, and they really are interested in how we will proceed. That's why this is the good opportunity to have this webinar and to speak about the consequences. What the questions arise during the we are really proud, extremely happy that we have such a honored panelist here, and I'm happy that GIAC had this opportunity, that in this region, in this part of the world, we have pleasure to welcome these fantastic speakers. And on this day, and this is very important to speak, that this is not generally, it is specifically, I want to mention this, that these persons have very really experience with these topics and issues, as long as they have participated and they have been among others of the drafters of ICC International Court of Arbitration's guidance note on mitigation, the adverse effect of the coronavirus pandemic on arbitration proceedings. And so they have more experience, more practical so-called advices if we will do that. I think that we will be a little bit cautious with this, but still they are really that persons who will lead with the questions, what will be related to the virtual hearing, and really proud with that. The format of our webinar will be a little bit different. My colleague Ndanga will take a lead and take lead with the, and she will be the moderating, and same time she will engage with the questions, And on the other hand, Professor Mohamed Abdel Wahab, which I think that many of you knows him, and he's a very active professor, and maybe he doesn't need more introduction, but I have to remind some words about him. And I will start, of course, with Ndanga Kamau. He's the founder of Ndanga Kamau law firm, an international law practice based in The Hague, Netherlands, and Nairobi, Kenya. She advises and represents clients in international disputes, sits as arbitrator in international and ad hoc arbitration. Ndanga is vice president of ICC, International Court of Arbitration, president of ICC Africa Commission, also vice chair in International Bar Association. And I have to add that Ndanga is really nowadays is a rising star to be appear in near future, and really I admire her. And she's sitting in many conferences. He's excellent speaker and has really good experience with that. On the other hand, we have Professor Mohamed Abdel Wahab, really very honored to have in this discussion. There is really, but I have to, it's really a privilege and difficult to do this, but I will manage to point out the most core and the more important credentials. Professor is the chair of the Private International Law Department at Professor of International Arbitration at Cairo University, Vice President of ICC International Court of Arbitration, member of ICA governing body. He's also a member of Law and Arbitration. Professor serves as sole arbitrator, presiding arbitrator, and also party appointed arbitrator. He's a legal expert and also counsel, acting as a counsel. He has really very extensive arbitration experience, more than 200 arbitration cases involving parties from different parts of the world. He's also the member of the institutions. He has wrote many and editing the books, articles, published other the specific law, wrote on the law issues. And most importantly, what is the very context with this webinar is that he's the one of the first creator, and he created the pathway of the virtual hearings in arbitration. Very interesting. And this is the idea how institutions, how tribunals, and all the members and participants of the tribunal should bear in mind during this pandemic period, and for the purpose to ensure to render the enforceable award, and also to guarantee the smooth and efficient arbitral procedures. So in this point, I will end my opening remarks. Thank you for listening. And now I will pass my, not floor, but screen in this point to Ndanga. And please, you can, screen is yours.
Thank you very much, Beka, and good afternoon to those who have joined us this afternoon. Thank you to you, Beka, and to the Georgian International Arbitration Center at GIAC for inviting me here today. And of course, I cannot start without a personal recollection of my visit to 2 weeks in Georgia. And during my visit, I went to Tbilisi and Kutaisi, Tskaltubo, and even up to Mestia in the mountains. And during that time, I had a wonderful time enjoying Georgian hospitality. And frankly, I wish I could be there today and that we were having this conversation and discussion over a refreshing glass of Borjomi water and followed by delicious Georgian food. But one of the things that this pandemic has taught us is that personal and professional preferences are being superseded by the exigencies of the pandemic. And frankly, if I were able to travel to Georgia today, we probably wouldn't be discussing this topic of virtual hearings. So it's all contextual. And the reason that we've gathered, so to speak, this afternoon is to talk about a subject that is on the minds of a lot of arbitration practitioners across the world. And it's really to see how we can help counsel, parties, and tribunals continue with arbitral proceedings in a time of crisis or emergency. So thinking beyond just this COVID-19 pandemic and beyond, how is it that we can reform arbitration or change a few of the things that we do in a way that helps these three groups of people move along with arbitral proceedings. And as Beka has mentioned, and we've seen the publication of checklists and protocols and guidance notes. And it's quite easy to be overwhelmed by the volume of material coming out and to be distressed about the way in which we can distill the information and really focus on it in a way that helps us in our own practices. But I see this change, this evolution as a positive thing, because for the first time, we're seeing, maybe not for the first time, but we're now seeing the international arbitration community rallying behind a redesign of international arbitration architecture, a very important component of it, which in this case is arbitral hearings. And, as we know, with any redesign project, you see the scope creeping. And we're starting now with virtual hearings, and who knows, before too long, we may be addressing voluminous pleadings and even embracing mediation. So we're really at a point where something is changing in the way that we practice, in ways in which we can do this in the best way possible for the parties as well as for institutions and for the practice more broadly. Now, today, we have the pleasure, as Beka has already said, of having one of those architects here with us. And we're really, and I don't know how one can overemphasize Mohamed's work in this area. He has been involved in drafting, reviewing, and a couple of months on this topic, but has also been involved in thinking about virtual hearings before this time. So I don't know that we could have any better person to have this discussion as embodied, as Beka has said, in his drafting of a pathway to virtual hearings, which is a mechanism which I think adds a lot of value to the way in which we approach this stressful time as we try and keep proceedings going along. And with that introduction, I would now like to turn to Mohamed. And the format of this discussion will be that I will ask a few questions and then hand over to Mohamed to answer them. And we'll have time at the end where you can ask your questions. But I really want to start, Mohamed, with thanking you for joining us in this discussion, first of all, but asking you to perhaps give us an overview of some of these instruments that you've been involved in drafting, in reviewing, in thinking about. We can mention a few that have been produced by the ICC Court, by the Africa Arbitration Academy, by the Chartered Institute, and so forth. And you can tell us more details about that. But can you tell us, what they are, how they all fit in together, and why they're important? Thank you, Mohamed.
Of course. Thank you very much, Ndanga and Beka. Let me first start by thanking both of you for the kind invitation. And Beka would know that a couple of years ago, I was invited to the Georgian Arbitration Day, but I couldn't make it physically. So at least 2 years later, I'm able to make it virtually. And secondly, to Ndanga, because Ndanga is not only a prominent practitioner rising star, but I, in all modesty, would say that she is a bright African face of international arbitration. Her capabilities go well beyond the continent internationally, and I'm delighted, having worked closely with her. I'm sure that the continent, with people like Ndanga, and we have very promising colleagues on the continent, African arbitration will contribute, and Africans will contribute to the world of international arbitration for the years to come. Now, briefly, it is quite interesting. I want to take a step back for two reasons. People tend, nowadays, we have on a daily basis seminars on virtual hearings, on elements of use of technology. And having been involved in a number of them, and some of our colleagues who are here today have attended those as well, you have to find something new to say, something different, so not to repeat yourself. But a step back, there is really a parallel universe called online dispute resolution that has been in existence since 1996. So we're talking now basically 24 years ago. And I've been involved since 2000 with this group. We have an expert group on online dispute resolution. That was indeed an area that I've worked on for the past 20 years, how to use technology in arbitration. And of course, it all started with an element of fascination by some, interest by few, and the overwhelming majority of people felt that it's a luxury, it's something on the side, but it's not how we do major international arbitration cases. And in 2010, I gave a paper in Vienna, and I said, maybe many people think that technology is a luxury now, but it will become a necessity very soon. And I think the necessity has arrived, at least in part, in relation to virtual hearings. That said, virtual hearings in and of themselves are not online dispute resolution as such. They're a component that can be part of online dispute resolution or part of traditional arbitration proceedings. For the moment, we are making the transition globally from a physical appearance in arbitration to a virtual appearance. And to respond briefly to Ndanga's point there, yes, there have been a lot of initiatives out there. And I was quite fortunate, together with Ndanga, who I thank for the excellent work she's done. We have worked initially on the ICC guidance note with many other colleagues and have been led by Manik Sleeton and very prominent figures of the vice presidents of the ICC court and other members regarding developing a note on how to assist tribunals and parties at times of crisis like this, to go through and mitigate the adverse impact of the pandemic. Now, the ICC is known to many, and international arbitration, capable not only of prosecuting in-person physical hearings, but also virtually more than capable of doing so. And many institutions have followed suit and have rendered guidance note. There is, of course, the Stockholm, which was before the guidance note of the ICC. There are others like the AAA ICDR. Many institutions have provided guidance note, and more to come. The idea was, this is a new situation for many people, and how should tribunals and the parties deal with it? And that prompted certain initiatives as well, apart from the ICC note, which is very helpful because it includes a lot of information regarding ICC arbitration, but also very helpful techniques to international arbitration generally. So it's not only for ICC arbitration, but for the global arbitration community at large. But there is another very important initiative, which is the Africa Arbitration Academy Protocol on Virtual Hearings. Again, I'd like to call them the Magnificent Seven, the people, the young minds and brains behind the Africa Academy. They reached out, and we wanted to work on a virtual protocol for Africa, so that we constituted a drafting committee and then a technical review committee, both of very prominent practitioners, and it was gifted to the world at large regarding the future of arbitration Africa and virtual hearings tailored to Africa, with very innovative features in the Africa protocol, including a suggested clause for virtual hearings, including technical specs as well. Many innovative things to consider. And it is also intended not just for practitioners, for African governments and institutions to embrace it and use it for African arbitration and arbitrations involving African parties, not necessarily wholly African in a way. So that is, again, a second initiative that I'm very proud to have contributed to again. And then thirdly, we have the Chartered Institute of Arbitrators. This I have to say, very limited role. The Chartered Institute is very close to my heart, and as well being a trustee on his board now, and we're quite fortunate, I think, to have the president-elect Anne Ryan Robertson on the people who are joining us. So she's the incoming president for the Chartered Institute, and they worked on a very promising summary note to the parties regarding virtual hearings. And there are many prominent colleagues, by the way, on the Chartered Institute's board, as in the directors, like Dr. Paresh Kathrani, Mercy McBriar, who have a very a broad and diverse interest in technology as well. So these are 3 examples, but there is more. And I think one very useful repository out there on all what has been written that is regularly updated in relation to virtual hearings would be the DELOS type of checklist. They have a checklist, I think now it's in the range of 45 or 46 protocols or initiatives dealing with virtual aspects of the hearing. And so this is being updated. So I commend them on the work they have been doing in this respect. And it's of course accessible online. This is in a nutshell, I think, what's happening in the virtual world. I was just telling Beka and Ndanga before we went live with this seminar that over the past week, I've received no less than 10 emails from entities that has sprung into existence regarding assistance they provide with virtual hearings. So they offer themselves with their services, and that's quite interesting, as to not only giving a platform, because there are many platforms, one of which we are using at the moment, like Zoom, but they are offering services to assist counsel and parties with their virtual hearing preparations, giving them technology to use, walking them through opportunities they can assist with. And it goes beyond document review to actually training on the use of platforms for the purpose of arbitration hearings, which is very interesting, because in as much as these institutions are increasing and have sprung into existence, the essential question is what arbitration experience have they had to be able to provide assistance with online arbitrations or virtual hearings for traditional arbitration proceedings. But it's an interesting area that we will see a lot of business developing and progressing along these lines. This, again, I have to say, at least on a couple of those initiatives, I had the pleasure of working with Ndanga, and I know how hard working she is, and she's always has very insightful and skillful contributions to make. But I think it's time, at least, for the world to rethink how we do things, and whether we can pool the efforts together of these virtual hearing notes, guidance, to come up with what one might think as a uniform or harmonized approach to virtual hearings in a way. There is one thing that I would like to mention. There are 12 arbitration institutions under the IFCAI that came up with a note regarding the encouragement of moving online and progressing cases in accordance with the requirements of efficiency and expediency, with due balance to considerations of due process. These 12 institutions, of course, include the ICC, LCIA, Cairo Region Center, the Stockholm, the Milan Chamber, and many others. The Singapore International Arbitration Center, which I think they're also doing a lot of work in that area. So a lot is being done, but it's a learning process to many. And I think towards the end of these few months, we will be able to charter a right course as to how we take an approach to virtual hearings generally.
Thank you very much, Mohamed. So all these instruments will assist, and protocols and approaches will assist parties and tribunals in moving forward with virtual hearings. But we can imagine scenarios, as Beka has already foreshadowed, where the parties may object to these hearings going forward. And it's then up to the tribunal to take a decision on these issues. And this is where your pathway, of course, comes in. But before we get there, you mentioned mitigation during your response a few minutes ago. And I thought perhaps you could give us a few comments on other mechanisms that parties might use, parties and counsel and tribunals might use with respect to case management to move things along that are not virtual hearings themselves, but which could assist with the process, particularly in situations such as those that we have now with the COVID pandemic.
Yes. So the ICC has a very useful appendix normally to its rules regarding the efficient management of proceeding. And that generally, it's not just for physical or in-person type of administrative proceedings, but they can equally apply. And the guidance note, which Ndanga was a very prominent member of the drafting committee we have in the ICC note, includes some of those innovative techniques. Amongst which, of course, is that one might think whether there are elements of the case you can dispense with the hearing altogether. You can decide a case on the basis of documents only, whether you will need to consider different approaches like reducing the areas of dispute between the parties and considering how to proceed. One thing that I personally thought of, and I'm currently advocating, is the following. We have to reconsider how we prosecute cases online. And one aspect that I'm personally, as I mentioned, thinking about, and just mentioned it last week, is why don't we think of having a mini hearing after the first round of submissions? A mini hearing for the parties that would be interactive, not only to give them feedback on the tribunal's thinking and on their submissions so far, but it would, as a matter of fact, be very helpful in distilling issues and ensuring that the second round of submissions would be limited to issues that are necessary, and then the subsequent hearing would be very limited. We will no longer need 2, 3, 4 weeks hearings at all. As I always say, I'm yet to see a case worthy of more than a 10-day hearing if the parties were to prosecute it on a daily basis on a full day. But I realize, of course, we all do counsel work as well as arbitrary work. So as a matter of fact, counsel need time to prepare. There's always a weekend, and there is always, time to prep witnesses and stuff like that. But if we think about it, assuming you take that idea forward, if there is a hearing after the first round, what will happen is the following. The statement of claim will be in full. The statement of defense and any counterclaim will be in full as well, because the parties want to put their best cases during the first round. They will not need to wait for the second round or even until the hearing for the tribunal to read in or so. But if you do that, it saves time, cost, and will expedite the process. And the parties will then go back after that hearing, virtually so, and think what they would need to include in their second round of submissions, and reconsider in a very limited version of a written memorial what would be of interest to the tribunal, having heard and interacted with the tribunal after the first round. And then when you go into the second hearing, the case will almost be ready one way or the other. So it actually prompts everyone to work. The counsel, the parties, and the tribunal will read in, because there will be a hearing, first and second. We will have limited hearings in time. Efficiency will prevail. And ultimately, you will reach a stage where the case will be ready for a decision much earlier than in many other instances across the globe. So this is one idea. The other idea is to consider to what extent witness testimony in a traditional way and cross-examination should be conducted online. I think many of us, having been involved in virtual hearings over the past few months, would know that people have been grappling to do what they do offline. And I think counsel is trying to be very efficient, to use their time wisely, because we know that the connection may not always be stable or seamless as one would expect. So they try to use their time more efficiently as compared to what we do in a traditional offline setting. So I think there is a lot to be done, not just in the traditional thinking, but in the way we prosecute cases. Procedural orders will need to be modernized, will need to be adapted. In as much as it took years to develop and harmonize the essentials of procedural order number 1, the nuts and bolts that are included in a template procedural order, I think in a virtual setting, and more increasingly with online arbitration, these procedural orders will include stuff that you would not normally encounter in areas in a non-virtual type of setting.
Thank you very much, Mohamed. So from what I hear you saying is that we should be looking beyond just redesigning the kitchen or the bathroom. We should be looking at the entire house and saying, you know, how can we make this a more comfortable place to live in the context of arbitral proceedings? And I think that these kinds of conversations are what will stimulate those discussions across the world. And I think we can all point to instances where we've had experiences where we know there are some inefficiencies built in, but it's just the way things are always done. So as Mohamed says, this is a moment to not simply recreate what we've been doing in hearing rooms online, but to really think more deeply about how we carry out witness examinations and so forth. Now, with that in mind, with this idea of innovation, we get to the pathway. And Mohamed will talk us through it in some detail. And what I would like you to start off by saying is, you know, who is it intended for? How should we use it? Where do we find the text? And so forth. And with that, I hand over to you to present the pathway. Thank you, Mohamed.
Thank you very much, Ndanga. So this idea of a pathway actually sprung into existence when I was responding, when we were actually reviewing the Africa Arbitration Protocol. And then internally, I was exchanging emails with two colleagues, due to me, of course, Abayomi Okubuti from the African Academy, who is one of the architects and the great minds behind the work of the Academy, with the other Magnificent Six, so all of them are the Magnificent Seven, and Sama Haridi, who was also reviewing. So it sprung to existence there. There was a question asked about what if the parties disagree as to the virtual hearing. So I provided the response. It was an extended response. And then when it was written, I received some feedback that you should publish that, because it actually captures what people might think to be all the scenarios that we thought about. So that's the idea behind it. And then GAR has kindly published it some days after I have written it. And the pathway is a succinct sort of document. It's a 4 to 6 step approach to considering how to approach the question of virtual hearing. And so if I were to be structured, the first point that I addressed was we need to look, of course, to the applicable procedural rules and the governing law, the lex loci arbitrii, or the procedural law of the arbitration. And I think in many arbitration rules, there is one term that features, two words specifically, in person, that features very often in laws and in rules. And many people have taken the position that in person means in flesh and blood. And when you look linguistically, you will find that it has a different connotation. It means that you appear, you make an appearance by yourself, not through a third party, or it can be in flesh and blood. And so the first point that I said, in person, what do they mean? I mean, I think all arbitral institutions and laws did not have in mind the idea that it could be problematic in the future. I think the perception was in person, more or less, versus an authorized representative or a third party. But I take it that others have thought about it appearing physically in person. So the first point, we look at those rules. And if the expression in-person hearings, or on the merits, if the word in-person appears, we need to consider whether it is synonymous with physical appearance or simply virtual appearance. Because we are all now virtually appearing on Zoom, but I'm appearing in person. I am the person speaking to you. You can see me. I'm not a different person. It's not a third party, not a rep. So I'm appearing in person, but virtually. You can't touch, communicate, or interact with me physically, but I'm still the same person. So from my perspective, this is the in-person. But I take it that there are rules and there are guidance notes and there are explanatory memoranda for laws and rules that may take a different approach. So when the tribunal and the parties consider this, they need to look into what is meant by an in-person under these rules and whether it is synonymous with physical appearance or not. So that's the first departure point in this respect. And it's addressed, as I mentioned, to tribunals, parties, counsel, not just to tribunals. And then secondly, what if we need to look into those texts to see if there is reference to possible use of technology or virtual hearings? And this is the dilemma, because many arbitration rules do not include such an express reference. The ICC rules, they do. include that reference. It's under the appendix dealing with innovative and efficient management and techniques, where you find reference to video conferencing and teleconferencing and stuff. But of course, it begs the question as to whether this applies traditionally in traditional arbitrations, that people do not use those techniques or not. But it's there. There are other institutions that may make this reference. Specifically, I can name, for example, the CTEC and the Shenzhen arbitration rules in relation to online arbitration. The CTEC has had their online arbitration rules since 2009, Shenzhen in 2019, and the Russian Arbitration Association have had their online arbitration rules in 2015. They all make reference to either documents only or the use of technology. But these are online arbitration rules. Traditional institutions have not included expressly such reference in their rules, let alone laws. When you look at the seat of arbitration, and this, it becomes very problematic, because these laws, they do not normally include such express references. In the pathway, I've made reference to the UAE arbitration law, number 6 of 2018, which makes an express reference to use of technology and video conferencing, which is very innovative. But in all fairness, there's another example. The Jordanian Arbitration Act of 2018, it was amended in 2018, and amongst the amendments is a reference to the use of video conferencing. So many arbitration laws are now contemplating this. Though, for example, on the African continent, the Tanzanian Arbitration Act, which was enacted in 2020, does not make an express reference to the use of technology. So you look at that arbitration law, you look at the laws of the seat of arbitration, but you could also be mindful of the codes of evidence, if applicable to arbitration. And I note one example is the Kenyan Arbitration Act does not make an express reference to virtual hearings, but the evidence law does make reference to that, though the challenge is that the evidence law says that it does not apply to arbitral proceedings. So you have these issues that you need to navigate through with respect to the applicable laws in this respect. So you need to consider the jurisdiction, the applicable legal system, and whether there is tolerance to the use of technology and virtual hearings in this respect. So that's the second point. If there is an express provision, so be it. That's very helpful. So my third point, what if the applicable law and procedure rules are silent and you cannot make a direct inference as to the situation, whether you can proceed with a virtual hearing or not? And here I say there are two possible approaches. One, either that the rule of thumb in these jurisdictions or under these rules is that absent of prohibition, everything is permitted. That is one principle. Or the opposite, that is, you can't proceed without an express provision. And this is subject to the applicable legal system as to which approach they take in relation to interpretation. Prohibition requires a provision, or permissibility requires a provision. And here I identify a number of elements that tribunals and parties can take into consideration. First of all, to what extent under the applicable law or rules tribunals have express powers to manage and determine the path of the proceedings as the tribunal deems appropriate. So is the tribunal's discretion limited, broad, have absolute discretion? These are all elements that you will find in arbitration rules and laws. And normally we have a standard language that says that the tribunal has the authority to administer and manage the proceedings in the most efficient way that the tribunal deems appropriate. And of course, this brings to mind one element of soft law as a soft law instrument that could be of benefit. That is the International Law Association text in relation to the inherent discretionary and implied powers of arbitral tribunals. This text is an interesting text, and there is a resolution in relation to it, and I invite everyone now to read through to see what powers can be afforded to tribunal under soft law. And of course, the element is to what extent tribunals can use this absent an express reference or agreement by the parties. So I assume maybe PO number 1 would now include reference to soft law instruments like this one, as much as protocols of virtual hearings. And then the second point many people overlook is that tribunals, when considering their authority, should look into whether the applicable rules or law provide that the parties have full or reasonable opportunity to present their case. And here I take a pause, because even though I come from Africa and the MENA region, and again, it's a very rich environment for arbitration cases and knowledge, because people are quite litigious and they come up with very innovative arguments. So you see a lot. And that's why I said tribunals need to look into these texts to see whether there is a reference to a full opportunity or a reasonable opportunity. Colleagues have written to me from the US and from Europe saying, in our part of the world, it's not that big deal. In developed countries, you take it, a reasonable opportunity is exactly the same as a full opportunity. But it's not always like that, because one developed jurisdiction, Singapore, take it for example. Singapore, in a case on the 28th of February 2020, the Supreme Court of Singapore rendered the decision in the case of the China Machine New Energy versus Jaguar Energy. And in that decision, they analyzed the reference to a full opportunity. And the court expressly said, full opportunity is not restrained by any implication of a fair or a reasonable opportunity. It could be beyond that. So this again affirms the point that tribunals need to be cautious and at least hear the parties on their views and take into consideration judicial decisions and precedents dealing, or authorities dealing with how courts would consider the issue of reasonable or full opportunity. And courts as well need to be open-minded nowadays with what's happening. And because courts have even moved virtually and are now conducting their business in part using technology or in full, depending on the jurisdiction, I think this will bring about more leniency and flexibility to accept the use of virtual hearings, even in the strictest of jurisdictions. So the status quo we're facing will undoubtedly will cast its shadows on how courts will approach the decision, bearing in mind the social distancing and the problems of gatherings or face-to-face physical flesh and blood meetings of this sort. So this is an element of full and reasonable opportunity. The other element is whether the applicable procedural rules or law provide for hearings as a mandatory requirement, and to what extent this mandatory requirement needs to be fulfilled physically. And here, I think most arbitration laws and rules do not have reference to mandatory hearings. You can proceed on documents basis or with a hearing, subject to what the tribunal deems fit. But there is a caveat to this point, because many institutional rules make a reference, even though hearings are not mandatory, but they could become extremely important if requested by one party. So if a party requests, a hearing will be held. And this brings us to the point, virtual or physical. So the idea of the mandatory nature of a hearing versus documents only, and then the mandatory nature of proceeding with a hearing at the request of a party needs to factor into the equation to avoid the risk or mitigate the risk of setting aside or challenges to enforcement. And then the other point is whether both or all parties, because we can have more than two parties in the arbitration, object to the virtual hearing. And here I think we need to take a pause, because arbitrators, at least over the past few months, have taken different approaches. Some have policed the parties into a virtual hearing, even though both parties objected to that and wanted to postpone it. And that's quite limited, I have to say. And there are others who, when the parties objected, decided, okay, then we will have to postpone the virtual hearing. And of course, then the question becomes, until when? There is no visibility. And there is another challenge that is factored, is whether there is a temporal factor that needs to be taken into consideration regarding the jurisdiction of the tribunal to render the award. So if there is a time limit to render the award, there will be a serious issue. And in that sense, tribunals, if both parties object, they have to obtain the parties' consent to extend the time limit if the tribunal is going to accept that, because otherwise they will lose their jurisdiction ratione temporis in this respect. So tribunals need to be mindful of this fact as well. But if both parties agree that no virtual hearing, the tribunal will need to consider the applicable procedural rules and law to see whether, despite the parties' joint agreement not to proceed with a virtual hearing, whether the tribunal can still impose or direct for valid reasons this hearing. And here we have to be cautious, because many arbitration rules and laws start the provision by saying, unless otherwise agreed by the parties, hearings would be held or so. So if that provision exists, the tribunal would be running a high risk if both parties object and they proceed, because there is an agreement by the parties. And this brings me to one of the innovative points, is that once these rules are studied well, and the laws, early on in our procedural orders, now number 1, or perhaps in terms of reference, tribunals should address that early on by saying the parties are in agreement in affording the tribunal the discretion to assess the need for a virtual hearing early on before the issue arises. So then it would secure the agreement of the parties, even in the presence of a provision saying unless otherwise agreed by the parties, because the parties would have then delegated or waived their right in this regard if they agree to do so. So this is again another element to consider. And of course, reference to terms of reference and procedural orders and whatever constraints on the tribunal's powers need to be taken into consideration. Down the road, when the hearing is months or maybe a year or so down the road, people sometimes do not review the terms of reference or procedural order number 1 where they have addressed specific issues, and then you risk contradiction. So it's important that tribunals foresee that, address it, and even ensure that their procedural orders are consistent all throughout the proceedings to the extent possible. And then, of course, the element of the time limits is indicative of how the tribunal should proceed, and I did address that. And then finally, the circumstances of the case as appropriate. So this includes whether the parties have access to technology. Access is one thing. Access to reliable technology is another thing. Access to state-of-the-art technology is a third thing. And we tend to package them all together. If one party has no access to technology whatsoever, this is a big challenge. And due process would manifest itself, not as a paranoia, but as a valid concern. And here the tribunal has to explore with the parties. And I think in one case, we've had the situation where the party said, I have no access to technology. We convened a teleconference with that party and explored whether they meant no access to technology at all, or no access to reliable technology, or that they are not comfortable with using technology. And towards the end of the call, what manifested itself, 2 things. First, it was their preference not to proceed virtually, but they have technology. Secondly, counsel was not comfortable with proceeding virtually because they are accustomed to proceeding in a non-virtual environment. And fleshing these issues out and discussing them in full transparency ultimately helped reaching consensus regarding how to proceed and giving it a try, at least, with part of the proceedings and see how it works. And it worked out well. But if there is no access to technology, obviously, there would be a red flag regarding due process in this regard, because the party can't appear, though I can't envisage a situation where no technology at all would be present. And then secondly, reliable technology. And here, if we go with a virtual hearing, reliable and reasonable technology is necessary. But we can disagree on what level of reasonable, reliable technology is needed. And here I think the assistance of technical people to ensure a seamless connectivity for a virtual environment, good platforms, internet connections, secure servers, these are all on the technical side of things that the different protocols have touched upon and addressed. But luxurious or state-of-the-art technology cannot be a bar. We all realize the situation where we have counsel or one party having full access to technology, full access to whatever state-of-the-art tools are available out there, which may not be available to the other party. Is that a breach of due process? It's a valid question, but the question remains that in and of itself, it's very difficult to envisage it as a breach of due process. It could be fact-specific, but think of it this way. You may have counsel that is outstanding, very persuasive, very experienced, and on the other side, counsel, this is their first case. Can anyone suggest there is a breach of due process? Can anyone suggest that you do not master the language of the proceedings and are not eloquent as counsel for one party, is that a breach of due process? Even if parties make these arguments, they have not been successful. So technology, I think, becomes part of this new package. To what extent we have access to technology, the second layer, reliable technology, and then the third layer is state-of-the-art technology. And I think this has to be explored by tribunals. And of course, again, the volume and type of evidence available is to be taken into consideration. And I'm not suggesting for a moment that voluminous cases are not suitable for virtual hearings, not at all. But people have suggested that. And I think we need to rethink our approach, because what actually happens, in fact, when you have voluminous documentation, you use technology to assist with this voluminous type of documentation. So people have to rethink the ways they approach virtual hearings in this regard. And in that sense, we have to consider the idea of how to approach virtual hearings. I am yet to be convinced that one specific type of cases or sectors, be it construction, oil and gas, or whatever, are absolutely not suitable for virtual hearings. I'm yet to be convinced about this. I think this has to be assessed on a case-by-case basis. It has to be considered, and in light of these elements. Then the final element, what if the procedural rules and the law are inconsistent with each other? So you have the procedural rules providing for something and the possibility of virtual hearings, but the applicable law in the seat of arbitration is against this. Then you will have to engage into an analysis as to whether the rule under the applicable law is of a mandatory nature or not, depending, and receive submissions from the parties on this. You need to involve the parties. It's a party-driven process, and consider what risks are there regarding the award if you are to proceed one way or the other. This is pretty much the pathway on the legal considerations that I have proposed. But of course, people may disagree. It's just an attempt from my side. Thank you.
Fantastic. Thank you very much, Mohamed, for that exposition. Just to the participants, to let you know that you can ask questions. There's a Q&A button which you can use. We're going to move to questions shortly, but before that, I have two quick questions for Mohamed. The first is, you mentioned due process and paranoia, and it's not uncommon to have these discussions in the arbitral community about due process paranoia and how it impacts on a tribunal taking decisions, particularly where there may be some disagreement between the parties. And of course, this is driven by the desire to have awards that are enforceable. Now, when you think about how the pathway will be received by tribunals, you have a whole range of tribunals. You have those that are more experienced and those that are perhaps less experienced. So what would you say to those who are less experienced, who are perhaps more inclined to this so-called paranoia, to reassure them that they should be taking perhaps bolder decisions and perhaps some tips from one who has practiced and from counsel who would be challenging those decisions? How should they be approaching this process? And the second question, sorry, you can answer them sequentially, is where do we find the text of this pathway? I know those that have access to the GAR can access it there, but for those who don't, where can they find
I'm happy to send it, and I can send it definitely to Beka as well. You have it, Ndanga, of course, and you've been very kind to comment on it. It's been a privilege to have you as a commentator. So I can definitely send it to anyone. As I mentioned, I was delighted to know that some of our Chinese colleagues have translated in Chinese and it's been used there in Portuguese. So I have to say I'm overwhelmed by that, but gladly I can send it to anyone and make it readily available. I'm also working on an article for the New York journal on this pathway, so it will feature there as well. So happy to give it to anyone as necessary and make it available in public, of course. On due process, I think due process is one of the areas, just like public policy, and in fact, it's a procedural dimension of public policy, where it's being invoked all the time. And in fact, its value has been diluted by the overwhelming usage and reference to it. Due process is definitely something that tribunals should be tread carefully in relation to, but there are many instances where people flag due process just out of a scare tactic, abusive tactic of some sort, or perhaps blowing things out of proportion. And I think tribunals need to tread carefully and consider, after hearing both parties' positions, you need to receive submissions, why this due process, legal authorities on the matter, and consider it accordingly, depending on where you're sitting and where enforcement will take place. But there's also a degree of reasonableness and sensibility, and a fair-minded, objective person would approach it. And I think that should be the test in a way. And in doing so, I think tribunals, if you sit as an arbitrator, you should not shy away from taking decisions. And I think that is an issue for some in the arbitration community. You sit as an arbitrator, you take a decision. But in doing so, you do not rush into taking a decision. You listen to the parties carefully, not in a delayed way, and then take the right decision at the time and make sure that you reason it, you make it to the extent possible, at the end of the day, explanatory to the parties. At the end of the day, you want to convince both parties. And I think sensible counsel on both parties' side would understand and accept when they receive a sensible decision. The question sometimes is that counsel may sometimes test the tribunal. It's like children testing their parents in a way. They want to see to what extent the tribunal will go, how far the tribunal would be willing to take a certain decision. And I think tribunals need to set the stage from the very beginning on their expectations, transparently discuss that with the parties. And during the case management conference, during the procedural meeting, whatever you call it, set out their expectations to the parties and make the procedural orders clear enough so that all elements are addressed well in advance and they deal with it accordingly. And if they do that, they charter a path and a roadmap to the proceedings that will, to a large extent, minimize the level of, let's say, disagreement between the parties. But of course, it's unavoidable. And there are situations where tribunals have to take a stand. But when they take it, they need to take it reasonably after carefully considering the parties' positions in a very reasonable way in accordance with the applicable laws and rules.
Thank you very much, Mohamed. Beka, I don't know if you have had...
Yes, so far there is no questions. Maybe I have a question and also a small remark, very small. We see that nowadays we are writing our practice now. I mean, in terms of challenges, in terms of refusal of enforcement so far, and also by today, we don't have, I'm not, by the moment I have not heard about the court decisions regarding the due process, irregularities. So we are in the way, we will see the court decisions on that. For now, for time being, we don't know what the legal culture will be, what the different legal culture judges will deal with that. So now I'll go to the question, and it will be directed to Mohamed and also Ndanga. Maybe you will have the idea on that. We know that this new world, these new mandatory or not mandatory virtual hearings gives us possibilities, and also these possibilities can be divided in two ways. In terms of, for example, dilatory tactics, and for example, in terms we are very fairly want to continue, want to settle the dispute. It is a way. So as for there is possibility, we don't know as a consuls how we will use it, but we will use it in terms of very good interest of our clients. And so in this respect, the tribunals have to be very cautious, very careful, and all the tension is going over the tribunal. What do you see? What is it is very difficult question, but what is the balance? Where is the line? I understand that as Mohamed said, that it should be assessed as the reasonable person and his reasoning should be interesting. But where the balance? What other opportunities has gave this new technology and the virtual hearing, and how it can be used by tribunals? Where the balance? Well, how we have to restrict? For example can be that maybe the council will use this there is no internet at all. They are using it. There is possibilities. One side and another. Where is the line? How we have to assess from tribunal side? Because at the end of the day, it is very interesting also from the council side. Maybe I figured my question and also the remark.
Ndanga, would you like to share? I think you're on mute.
Sorry, Mohamed, please go ahead. Please go ahead.
So, okay. So it's very interesting, Beka, and I think, as I mentioned, tribunals need to tread carefully. Let me just mention something, a word of caution. At these times, I would caution against any predispositions. So some people may think if an objection comes from a respondent, oh, they are delaying the proceedings. It's not always like that. And people should have an open mind as to the objection, not who is making the objection. As to the comment, not who's making the comment. Some people may, for example, you may have a situation where the claimant itself does not wish to proceed for valid reasons and is unable, because of lockdown, curfews, or whatever, to proceed in a certain way. This is not a delay. It's simply because there are valid grounds to do so. But in brief response, I think the best way to do it is to bring the parties on board and discuss it with them. And I'll tell you one in a very recent case, just a couple of weeks ago, we held a virtual hearing, but it was interesting because one party was firmly objecting to holding a virtual hearing on the merits. So they provided some written comments and submissions. And what happened is that I discussed it with my co-arbitrators and I told them, let us try something. Now, of course, let's ask them to convene a meeting to discuss their views. And of course, because of the social distancing, because of the lack of travel and people in different locations, and because telephone may not always be reliable, let's hold a virtual session, a procedural one, to discuss it with them. So council joined, we discussed it. The virtual meeting went very well. So at the end, we asked whether any council had any objection after we've heard them. They said no, but we want you to decide on the view, whether you want to proceed with the virtual hearing or not. So I told them, now we've had like 2 hours of discussions online. Was any of you uncomfortable? So that's when the party was objecting realized that the position was that we are actually doing it online. He said, no, but maybe a hearing on the merits would be more difficult. So I told him, yes, maybe then is a step forward. So then realize that it's a possibility and it worked well now, thank God. So why don't we do is that both parties consider whatever platform they wish, the time they need to work out the details. There are many protocols out there, consider them, discuss it with the parties themselves, and let's do a trial of the merits of the hearing. And that's how it worked. And ultimately, we did not need to decide on the objection because the parties agreed to give it a go. So I think it's easier to have a disagreement when people are writing and exchanging communications and letters and stuff. But when you hold a meeting, there is a degree of sensibility. There will always be a moment when you as a tribunal make a sensible point or the other party makes a sensible point. The other party will find it difficult to argue. It will look ridiculous. So there is the moment that you can grab as an opportunity to discuss a path forward in this respect.
Thank you. Thank you. Ndanga, you may.
I have nothing to add to that. Just checking to see if we have any questions, if anybody's trying to ask a question. Otherwise, I may have some follow-up questions for Mohamed. Unless, Beka, you have something else you'd like to ask?
Maybe I will let you. There is something, maybe, Ndanga, do you see?
I see it. Ah, yes. Somebody has 2 questions for you, Mohamed.
Yes.
The first is, surely there are some cons for the remote hearings. Do you expect a more conservative approach in the new generation of arbitration agreements where parties clearly specify that hearings should not be remotely held unless both parties agree in writing? That's the first question. Perhaps you can start dealing with that while we wait.
Yes, thank you very much, Mustafa. Delighted you could join. Now, very simply, your point is, of course, the parties can agree to do so. And if the parties expressly specify this in their arbitration agreement, then there is virtually nothing, if anything, that could be done by the arbitrators to counter that, especially if it's in the arbitration agreement, unless they wish to amend it. So that's the immediate response to if the parties do that. I wonder why the parties would include it in the arbitration agreement in the first place, because that could affect either or both of them, depending on who has a vested interest to expedite the arbitration. But there are cons. I can't say that there are no cons. Of course, I'm not saying that we should all go virtual. I'm simply saying the following. Look at the history. What has happened? We have always had procedural hearings or meetings or CMCs and hearings on the merits, more or less, if it's not documents only. And the idea initially was that the first preliminary meeting would be face-to-face, in person, people sitting in the room. And then gradually, the arbitration community internationally moved away from the default situation of a procedural hearing in flesh and blood to a procedural hearing by telephone or by video, under the pretext that it's more cost effective and it's much easier to schedule because people cannot travel a whole day from across the globe to meet for a procedural issue. So the idea was that this was the default situation, and then a party wishing to hold a procedural meeting or a CMC physically in one place needs to provide compelling reasons to do so and to decide how it's going to deal with the costs. But no one touched the hearing on the merits. So we moved away from both being in flesh and blood physically to one being, more easier through teleconference virtually, and this became the default position. What we're witnessing now is that virtual hearings at present are apparently the only option for an international case where you can't gather people in one room, because we're all forced to stay in our homes one way or the other. At least there are no flights. Or even if you go, you need to quarantine for 14 days before you go into the hearing. So it's not an option at present. In the future, it will come back. And the question would be, which one of them will be the default situation? The virtual or the physical? And I am saying they will both become of equal importance for some time. And I'm telling you, and I mentioned this a week ago, I am concerned that sometimes arbitrators will pick and choose to move in which direction, physical or virtual, depending on a preference to go to the destination. So if you don't want to go to the destination, previously you had to go because it's a hearing on the merits. Now, well, let's do it virtual. It worked well during the COVID-19 and afterwards. Why don't we try it? There is no issue. So I would caution against that. I think it should be based objectively, not on the basis of preferences. But I think to answer directly on the cons, I think the major concern is the connection, the ability to present your case comfortably virtually, the ability of the tribunal and counsel to deal with the case and the documents in the manner they were comfortable. It's born out of tradition, as we were comfortable in a different environment. But if we're forced and it continues for a longer time, people will feel the comfort of doing it online because they have done it once, twice, 3 times, and now they know how to do it. I think the fears and the concerns arise from the fact that we have not done it and people have not experienced it, and you're afraid to try a new thing after you have reached a comfort zone on how to handle the hearings. But again, the technology would be a challenge, but history has proven and time has proven that technology is instantaneous, and a technology is out there and it's outdated in less than 6 months' time. Let me give you an example. 2001, I wrote an article. I mentioned holographic visual projections, and people were laughing at me. 2001, literally. And now you see holographic visual projections in airport, Heathrow, Dubai Airport, and others. You see a holographic visual projection. And I am confident that 100% you will find that people will be appearing in 3 dimensions in virtual hearings as if they are really physically in the room. The question is, I would like us not to completely disregard the physical element, because part of the human nature is the interaction we have. But it will be a practice, virtual hearings, whether we like it or not. What happened is that COVID-19 expedited and accelerated this.
And there is a second question.
There is.
The
second
due
question.
process and cross-examination.
Yes, exactly.
Yeah,
exactly.
That's interesting. I think so far, especially for our colleagues from the common law world, cross-examination and witness testimony is of extreme importance. And I'm not even stereotyping, because for many civil lawyers, they can do very well with a cross-examination. The idea is, traditionally, it has been a very important component of hearings when there are witnesses or experts. And the challenge is that, this is a challenge, that people have not yet found a way to change the way of conducting cross-examinations, a different approach. They want to do the cross-examination in the same way they have done it in a traditional non-virtual environment. So developing lines of cross-examination, spending the time you want to the extent you don't have a chess clock with the witness, stuff like that. I think virtually, it's very difficult to spend now a day and a half cross-examining a witness virtually. I mean, neither the tribunal would expect it unless there is necessity, nor would it be as productive or impactful as one might think. But there are cases that may require this to be the case, or if you have one witness or so. So I think in terms of cross-examination, the challenge would be, as a cross-examiner, to choose your lines of cross-examination carefully, to choose your questions prudently, and to ensure that at the time when you have a seamless connection, when the tribunal is fresh and listening and understanding, that you use the most of your arsenal in terms of cross-examination during that time to make it as impactful as possible. But I think we need to rethink, as Ndanga has mentioned, looking at the whole house, not simply the kitchen or the living room. You need to reconsider the approach to prosecuting proceedings online.
Thank you, Mohamed. We have another question, which is about arbitration being held from A to Z online, and that's in the Q&A section. And the question there is, what happens to the seat if the arbitration is held completely online? If, for example, the seat is Vienna and the parties are in Africa and Asia somewhere, and the arbitrator was in England, what does that do to the arbitration?
Yes. Now, of course, when you read the online arbitration rules of institutions, and they're really in relation to online, and I suspect that many, many more institutions will develop online arbitration rules, you will find that there is no specific reference to this issue of the seat. But let us consider it. The legal seat is a legal fiction that is created to create the jurisdiction of the courts of primary competence to decide on elements in relation to arbitration, be it setting aside appointment of arbitrators if there is no agreed mechanism of appointment, or if it's ad hoc, stuff like that. So this has no problem whatsoever. Still, you can agree a legal seat in an online arbitration that will determine which court will decide. The problem would be if there is no agreement. That is the essential point. How would you decide it? Is it the legal seat would be the place of where the institution is located, if there is institutional arbitration, where the platform on which everyone logs in is located, where the servers are, where the arbitral tribunal is? I think these are all very valid questions, choice of law questions, that need to be addressed early on by tribunals and the parties if the parties have not agreed the seat of arbitration. And then there are certain rules that do not decide that tribunals will determine the seat. For example, the ICC rules, if there is no agreement on the seat, it's the ICC court that determines the seat. And then the court or the institution will need to take all this into consideration. The elements or the connecting factors that will determine the center of gravity as to the legal seat, bearing in mind the domicile, nationality, the location, not only now of the parties and counsel and the arbitrators, but the technical platform of the equipment that you will be using for the online arbitration.
Thank you very much, Mohamed. I think we're sort of coming to the end of this session. I have a couple more questions that I'd like you to answer, but I don't see other questions from the participants. Beka, did you have any questions before I
no,
ask?
you can proceed, and then we will have a couple of minutes, and then you can ask the question.
Fantastic. And I think Mohamed has generously offered to share the text of the pathway. And I think when you do that, you may find that you get more questions from the participants and others more broadly. And I hope that you'll be open to sharing your, as you always are, sharing your expertise with that. But now I'd like to move on more to looking at the future, to this idea of redesigning the whole house. And, you know, we've been talking about the proliferation of webinars, not just in international arbitration, but more broadly. And you keep hearing this phrase of you should not waste a crisis. And nobody knows exactly who it's initially attributable to, but I'll join with a cliche and ask this question here. So if we're minded not to waste this particular crisis, and we're looking to the future, you know, we've had discussions in other forums about the possibility or the opportunity for technology to democratize knowledge and expertise. So here, if we think about institutions such as GIAC and others across the world, which are now perhaps more accessible and more reachable than they might have been before. So the first question is, what advice do you have for them? You know, how do they make sure they don't waste this crisis? And here also bearing in mind the limitations on technology, the limitations on internet access and bandwidth and so forth. You know, what would you say to these institutions? And the second question, which perhaps will be the last, is where do you think our other blind spots are? So in international arbitration, you know, we realized that we had a blind spot with respect to how we organize hearings. Some of those had been resolved before by you know, the first procedural conference, as you already discussed, case management conference. But what other blind spots do we have, which may be unrelated to virtual hearings, that if we want to look forward and if policymakers want to be ready for the next crisis or be ready for the next emergency, where should they be looking? Which sections of the house should they be looking at? I hope those are clear enough.
No, they are, and they are excellent questions. And I will even use this in part to respond, I think, to a question by a colleague who just posed about the body language of witnesses. So I will use that in the context of responding to this. Again, excellent questions. What institutions need to do? There are ideas that are clear in my mind, but I think institutions looking into the future, those who want to take a proactive role and position themselves as leading will need to develop their own secure interactive platforms, not simply outsource this. I think having this in the house is a value-added tool. This is the case you're administering. To minimize risks of access, outsourcing, you need to have your own platform. And I have advocated this, but of course, there is a financial business model feasibility study to consider whether it will be used or not. COVID-19 has shown that it was a worthwhile investment, and now it's a necessity. So if the first thing you need to develop this, and it should not be a passive platform, it should be interactive, user-friendly, and free trainings given to counsel and parties to show them the beauty of these platforms and how it would help reduce time and cost, and it would be round the clock available with unique access to participants in a way. Think of it when you deal with banks. You don't have a bank that outsources that online banking. It's their own platform in a way. I recognize it's a distant analogy, but for arbitration, and some cases are high profile, important, and there is confidentiality and security concerns, you need this. So that's the first point. Institutions, they need to do that. Secondly, institutions need to reconsider their arbitration rules in part, or develop a set of online arbitration rules. But if they go with an online arbitration rules, it must be a paperless arbitration where there is no room for physical interaction or hard copies of any sort. And people can resort to this. And it's not tailored only to small value online transactions. It can work very well with the traditional offline disputes. And then we need to rethink how to tailor technology. Technology, to the extent we're using it now, we are so far using a small proportion of what we call ICTs, information and communication technologies. We have not yet used artificial intelligence in arbitration and dispute resolution. And I think that's important. And this ties in to the question about the body language and stuff. Our colleague was asking, still, you can't compensate for the body language. You understand the witness. You see whether they're lying or not. But not, well, that's true so far in relation to arbitration and how we've been doing things. But there are two caveats to that. First one, we have to be cautious when we talk about body language. It's not one size fits all, because the people come from different cultures and different backgrounds. The way of using the hand, the body, the sight, anything that you do is partially, if not wholly, dependent on your culture and your background. So it could be perceived differently by others in different jurisdictions. And this is a science I'll tell you, in translation studies, they have something called face-threatening texts or acts. So in some cultures, you use your hand, like I'm using now, or so. It could be impolite. It could be not acceptable. In other cultures, it's a sign of passion, engagement, interaction. A witness who's testifying for the first time, there is a degree of discomfort. His body or his discomfort is not necessarily a manifestation of him being lying or not convinced about what they're saying. So that's my first caveat. We have to take the body language carefully. But of course, there is a sense, and you know when a person is potentially lying or not. I understand and I take it. But the point is, technology has reached a stage where you can determine this. There are technologies out there that we call eye catcher. You can see the wink of an eye, you can see everything clearly. We have not yet used this in arbitration. And imagine with a three-dimensional holographic projection, it could be as clear as the physical body in a way. This brings me to the innovations about witnesses. One of the scary things that will eventually happen, so far we are relying on individual human views and perception and reading of the witness. There are functional magnetic resonance imaging devices, it's like a scanner, that can be used and attached to the brain that tell you whether the statement is like a lie detector, is right or wrong. So imagine if you now integrate that into witness testimony in a virtual environment, how effective this could be, and how what impact would it have on using witnesses in arbitration? It could result in a situation where people will resort less and less to witnesses, or you will have a new business model of coaching witnesses in dealing with detectives as to how they say it. So out there, the opportunities are immense. And then the other option of using artificial intelligence is the self-learning, multi-valuable optimization programs, where you would use technology to develop optimal arguments. So effectively assisting counsel to come up with persuasive arguments and tribunals to dealing with complex issues. So instead of relying on our individual skills as humans, you could be up against artificial intelligence that could counter our human skills one way or the other. So those very prominent advocates and stuff, imagine a machine, you're feeding into it the greatest advocates of all time, the greatest arguments being made, and then that machine, through an algorithm, comes up with a technology and a set of arguments to use in your case after feeding in the information that you can simply take it as an output and use it. this is scary, because then the individual skills could largely be diluted by machine learning impact that will change the profession forever. And that is even at the level of human versus artificial intelligence. But I'm telling you, and this is a technology that's being tested, handheld devices are not going to be the near future. You will have it a chip under your skin, and you will move things and dial with your hand. Imagine the impact of this on dispute resolution and arbitration when people will have an integrated part of artificial intelligence within them. So it's like the cyborgs of the science fiction, where you have part human, part Borg. This is very scary. I'm not sure I would want to live during that period, but this is going to happen unless something happens to technology and we dispense with all the technology all over the world. But again, these are all the blind spots that I see, the spillover to technology. So far, the dispute resolution world has been closed, has been conservative, with few penetration or permeation of technology. Now, with the virtual hearings, many of the technology tycoons, companies, realize that this is lucrative business, and tailored models for using technology will manifest themselves, and this will be transformative in the way arbitrations are conducted forever.
Fantastic. Thank you very much, Mohamed, and for ending on that sobering note. We may all need to start looking at alternative careers before too long. And with that, I think what remains is for me to thank Beka and GIAC for this opportunity. And I very much look forward to my next visit to Georgia, although bearing in mind that we need to be more thoughtful about in person, but to be more thoughtful about our travel, considering the impact on the environment. So that's something that perhaps is a good outcome also of all of this. And Mohamed, I have no words. As always, you have shared with us your rich knowledge and experience in all of this. And I know that those who are listening and those who will listen afterwards will benefit greatly from your generosity, really, with your time and with your knowledge. And I think, you know, when I spoke earlier about the arbitral community coming together to think about different ways of doing things, I think from your discussion, you've illustrated quite profoundly exactly what's happening, and that there are few people in this field who are taking the responsibility and spending the time in thinking about how we can do things better and how we can make this mechanism of dispute resolution more robust and more able to survive into the future. So thank you very much for that. And don't stop having these ideas and sharing them with us. It's a benefit to the broad community.
It's a great pleasure, Ndanga and Beka. It's always a privilege to join you. And as I mentioned, I value, respect, and wholeheartedly, I'm always grateful for your contributions. And thank you for having me with you today. It's a privilege and an honor. Thank you.
Thank you very much. Beka, over to you.
And finally, I will make it very shortly. Ndanga, thank you very much for your question, for your effort and preparation, how you prepared, and thank you really very much. Thank you for your also the references, and of course to Mohamed. Really, previously I mentioned with Ndanga, I remember that I was speaking with her that listening to him, to Professor, it is really one day you really understand, and the passion and the way of understanding, and really you understand the content, and it is not at all boring. It is really on point, and really appreciate. It was really delighted. It was honor to have in this part of the world you, and really your name. It is all over the world, and we are privileged to have you here. Ndanga, thank you very much. Again, I will recall your so that we will see in person. And very slightly what I wanted to say, we can discuss. We are saying that everybody is discussing, and it is very popular to have this kind of discussion, but I think that it is happening, and it will happen, and it will continue. People will speak about in this field and this technology, but finally we have to think about that the technology should serve humans. So main is, I think, that to render the enforceable award to have sometimes there is no justice, but we have serving justice. And in this process, I think the technology should serve us, and it should not have to be adversely affect to us. Then it is the rule how we will deal it and how we will manage it. And so it is. Also, I have to thank all the participants for the interest, and I'm sure they enjoy so much. And because it was really something to have, and those who has not come, I think that it is a little shame. But with the online, we will manage to cover all the others. Thank you again, and hope to see you in future. I think in person.
Thank you so
very
much.
much.